Court does call the case of the people versus Maya Hines.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Hines.
I have two cases. Well,
1487 is not stopping your house.
deal with that case. All right. With regard to the case that's on the docket.
Sorry. With regards to that case, Your Honor, people are unable to proceed.
All right.
Move to dismiss, Your Honor.
People being unable to proceed, that case, that being 1487, that case is dismissed. That is without prejudice.
I don't think Ms. Hines stated her name. Can you state your name, Ms.
Maya
Hines?
Hines.
All right. I do have another case for Miss Hines. I don't know. You know, in which she has a warrant. It's a case of retail fraud. You were set to appear before the magistrate, did not. A warrant was issued on that case. What I will do is this, that I'll arraign you on the warrant in the case. Ma'am, that case alleges that on or about January 7th, 2023, at the location of the Meyer store, 3825, or the other one. At the location of 3825 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you did commit the offense of retail fraud in the third degree. Do you understand the nature of that charge, ma'am?
Yes.
All right, that is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Fine could be increased if 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. Do you understand that?
Yes.
All right. First question I have for you, you want to be represented by an attorney?
Yes.
This is a public defender case.
Assistant Public Defender Lauren Perny on behalf of Ms. Hines will waive formal reading and stand mute to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to that charge. I will set a pretrial in this matter for November 5th, 2025, 9 a.m. or as your invite indicates. With reference to bond in this case, I will cancel the bench warrant in this matter. I will then set a bond in this case, amount of $5,000. Personal recognizance of other standard conditions, including no assaultive behavior or possession of any weapons. You understand that, ma'am?
Yes.
I'll also indicate you're not to possess or consume any alcohol, recreational marijuana, or any illegal drugs at this time. You understand that? I will also indicate that at this time also, you are not to enter any Meyer store in the state of Michigan. You understand that?
Yes.
All right. Thank you. See you on the 5th. Let's call the case People versus Jalen Robbins.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Robinson, who is approaching. State your name, sir.
Jalen Robinson. All right. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
My understanding is the defendant is going to be pleading guilty to the as charged to domestic violence, the 93-day offense. Upon a successful plea to that charge, at sentencing the defendant, there is an agreement that he will be sentenced under 7694A, the preferred program. That's the court's full understanding of the agreement.
Correct, Your Honor.
Correct.
Oh, very good. May I have him sworn?
You solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth that we got. Lower your hand and state your name.
Jalen Robinson.
All right, sir, it is this court's understanding you're going to plead guilty to the charge of domestic violence. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court cost. Do you understand that?
Yes.
All right. And understanding that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Guilty.
Thank you. Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Correct.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Nope.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
Nope.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of July 11th, 2022, at the location of 4820 Washtenaw, apartment B11, Pittsfield Township, Washtenaw County, state of Michigan. What did you do on that date involving a Giovanna DeMarco that makes you think that you're guilty?
Just touched her when she didn't want to.
Okay. Were you guys involved in a fight of some type or an argument?
Argument.
You were involved in
Verbal.
an argument
Verbal argument.
and you touched her in some fashion?
Yes. And without her consent.
Pardon?
Yes, without her consent.
Can we leave it open for a minute?
Man. So you said you touched her and she didn't, where did you touch her?
More so like the waist.
All right. And you didn't have her permission to do that?
No.
Okay. And you did that intentionally?
No.
You didn't touch her intentionally.
Mhm.
He's asking if you touched her intentionally, like it wasn't an accident, like you touched her,
Like it wasn't an accident.
like you touched her,
Like on purpose.
yes,
So yeah.
yes.
Okay. Yes.
Okay. I'll ask the question again. Did you intentionally touch her when you said you touched her on the waist?
Okay. Yes.
You did? Okay. And that was without her consent, as we've established.
Correct.
Correct. And what is her relationship to you?
Right now, or nothing.
It's probably not good right
Yeah.
now, but what was it at the time?
I'll say dating. Dating. Yeah.
I'll say dating.
Yeah. Cause we wasn't.
What was your relationship with her?
We wasn't boyfriend girlfriend. So I'll say dating. We were intimate. I don't know.
Okay,
Dating.
that works. All right. Sir, if I accept your plea, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and your time of sentencing, that the court would no longer be bound by any sentence agreement or evaluation of your case. You understand that?
Yes.
And also you would not be permitted to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
All right, and have the court complied with the court ruling would it be proper to accept his defendant's plea.
Yes, Your Honor.
Yes, Judge.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be November 12th, 2025, 9 a.m. Bond in this matter with its conditions. Thank you, sir. You can stop by probation on your way out the hallway. They'll be on your left.
Okay.
All right, thank you. Court does call the case, People versus Samira, is it Takora?
Alexander, on behalf of people.
Assistant Public Defender Natalie Pay on behalf of Ms. Takora, who I do not know or if she's present, Your Honor. I have had, oh, perfect, she's here. We talked on the phone. Ms. Takora, I apologize. Please state your name for the record. Samira Takora.
Thank you.
Your Honor, at this time, people are unable to.
Motion to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That's without prejudice. Thank you, ma'am.
Thank you, Your Honor.
Court does call the case of the People versus Nicholas Stimmel.
People.
And good morning, Your Honor, for the record.
Yep.
Good morning, Your Honor. For the record, Rita Young, appearing on behalf of Mr. Nicholas Stemmel, who is present standing to my right. Sir, would you state your name for the judge?
Nicholas Stimmel.
Thank you. I thought since you hadn't been here in so long, Michelle, you just forgot where to stand.
Kinda.
It is good seeing you.
Likewise, Your Honor.
All right. I have before me a plea form that indicates that the defendant will be pleading no contest to the charge of assault and or assault and battery, the 93-day offense. On his successful plea to, that's pleading as charged, there is an agreement as to sentencing that a prosecutor's deferred sentence with probation would be the sentencing case.
That is completely correct recitation of our agreement.
And Your Honor, it's my understanding that if successfully complete probation, the case will be dismissed.
That's right.
As part of the prosecutor's deferred. That's correct. All right. May I have him sworn?
You solemnly swear or affirm the testimony you're about to give, the whole truth, and nothing but the truth, have you got?
Yes, I do.
Lower your hand and state your name.
Nicholas Stimmel.
Sir, it is this court's understanding that you're going to plead no contest to the charge of assault and or assault and battery. That's a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. Two things about it. I have to make sure that you understand it. First of all, means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Still, basis for the no contest plea.
Civil liability,
All
possible.
right. Still wish to plead no contest?
Yes, Your Honor.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty or pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will.
Yes, Your Honor.
And well, I won't ask the last question. The court has been provided Pittsfield Township Department of Public Safety report for their case number 24-16014. Any objection to the court having reviewed that report?
None from the people.
None from the defense, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, after I accept your plea in between the time of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would, any sentence evaluation or recommendation to the court would no longer be bound by. You understand that?
I understand that, Your Honor.
And you also understand that you would not at that time also be allowed to withdraw your plea. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
None, Your Honor. And it sounds like the court's not amenable to immediate sentencing.
I wasn't asked, but
Oh, okay.
by being asked, no. All right.
Yes, sir.
You just don't want to come back here, do you? You're just trying to make it like a one-stop. I couldn't do that in any event because of the nature of the charge, and it's a victim's rights case, so I'd have to have him evaluated on that. But have I complied with the court rule?
You have, Your Honor, as usual.
Yeah, right. Court will accept the defendant's plea of no contest to this charge. Defendant is referred to probation
Thank you, Your Honor.
for a pre-sentence investigation and report. Sentencing in this matter will be November 12th, 2025, 9 a.m. or
Judge.
slide indicates.
I'm
That's
so-
why we don't let her come. Go ahead. What?
I'm so sorry. I have a jury trial scheduled to start in Wayne County on November 10th. And it's a CSC case, so it's going to run through the 12th, I'm sure. So I'd ask for a different sentencing date, please.
You know, I almost want to say no.
Can I zoom in for sentencing then?
No.
Okay.
No, we're gonna make you come here.
Very well.
Can we? The 10th?
Yes.
10th is when the jury trial starts.
Can't
Oh,
do-
December
can't-
10th, you said? Oh, that's great. Perfect.
Sure.
Yes, Your Honor. Perfect.
Sentencing will be December, actually, the 12th was perfect too, but you just messed that up. December 10th, 2025, 9 a.m. or as your invite indicates, bond with its conditions will continue. Thank you, sir.
Thank you
Your
so
Honor.
very much, Your Honor. Good to see you.
Take care. Court calls the case of the people versus James Baltes.
And then on behalf of the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Baltas. State your name for the record, sir.
James Lee Baltus.
Thank you.
At this time, people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
All right, thank you, sir.
Thank you.
Court does call the case, people versus Jason Eckel.
The people.
Good morning, Your Honor. Robert Goldman, PA 1222, appearing on behalf of alongside defendant Jason Michael Eckel, present in the courtroom this morning. Mr. Eckel, would you please state your full name for the record?
Jason Michael Eckel.
All right. The plea form that the court has in front of it is that the defendant is going to plead to an added count 2 of operating while visibly impaired to second offense. The 1-year offense. Upon the successful plea to that charge, count 1 would be dismissed. Defendant is also agreeing to enter and participate in sobriety court. Is there a particular sobriety court that he's going to be entering, or?
I'm not sure that he's been screened yet, Your Honor. Counsel and I had the chance to discuss this morning, and he let me know his client's interest in sobriety court. And given some of the facts and background here, I think that's a really good option.
Got
So
it.
I don't know that he's been screened.
Screened as, okay, but he does agree to do that. Is that correct, counsel?
Yes, Your Honor. And he is a resident of Ypsilanti. And so
You're not, right?
I'm not, no, Your Honor.
I could tell by the way you said Ypsilanti, but go ahead.
Sorry. So we are open to a sobriety court that has room for admission. I do believe that he would qualify as a resident of Washtenaw County. And otherwise, we anticipate it to be a successful screening for admission.
Okay, and I mean 14A has a,
I
Yeah.
think that would be a good place to start is 14A.
Yeah.
okay. And that's the court's full understanding of the agreement. Is that correct?
Yes, Your Honor.
Accurate, Your Honor.
All right, may I have him sworn?
Do you solemnly swear or affirm the testimony you're about to give the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand and say your name.
Jason Eckel.
Say that again. You.
Jason Eckel.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while visibly impaired second offense. That is a misdemeanor punishable by up to 5 days to 1 year in jail, up to $1,000 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
And understanding that, you still wish to plead guilty.
Yes, Your Honor.
And to that charge, how do you?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand by pleading guilty of those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
Besides my wife, no.
All right. You're doing this voluntarily,
Yes.
of your own free will,
Yes.
and because you believe that you are indeed guilty.
Yes.
All right. On September 4th, 2024, at the location of 3900 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, remember the questions we went through?
Yes. Yes.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes.
What you have and how much?
Mike's Hard Lemonade, about 3/4 of a tall boy.
Were you stopped by the police or was there an accident?
Your Honor, there was a welfare check was conducted. Officers responded by way of a dispatch for welfare. Mr. Eckel came into contact with officers in the parking lot of a Lowe's retailer in light of the welfare check response.
Got it. Okay.
No accident involved, Your Honor.
Okay. And ultimately, were you arrested
Yes.
and were you taken to the hospital for a blood draw?
It's an intoxilizer case, Your Honor.
All right. And were the results of that intoxilizer 0.09 and 0.10?
Yes.
Do you have any reason to dispute those results? Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes.
All right. And had you previously been convicted of operating while intoxicated on or about December 6, 2021 in the 1483 district court?
Yes.
All right. Sir, if I accept your plea, between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any sentence evaluation or recommendation. The court would no longer be bound by that. You understand that?
Yes, Your Honor.
You also understand that you would not be entitled to withdraw your plea.
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None, Your Honor.
All right. And has the court complied with the court rule? And would it be proper to accept this defendant's plea?
The people are satisfied.
So satisfied, Your Honor.
All right. Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be here on November. I'll set it for November 12th, 2025, 9 a.m. Bond will continue with its conditions. What I'm going to suggest to you, counsel, is to go down to probation at this point in time, indicate his interest in sobriety court, and see. There are 2 probation officers working down there at this point, my probation, as well as the sobriety court probation person. So let them know that and let them direct you as to how he should proceed.
Will do, Your Honor. Thank you.
Thank you. Court calls the case, People versus Eric Buckner.
Alexander, on behalf of people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Buckner, excuse me, who stands to my right. Please state your name for the record, sir.
Eric Buckner, how you doing today, sir?
Thank you. I have a plea form indicates the defendant is going to plead to domestic violence second offense, the 1-year offense as charged. And that upon his plea, the prosecutor will recommend defendant's pending domestic violence case in the 1482 district court will be dismissed with a nod.
That is the complete understanding of that agreement, Your Honor. Yes.
All right, very good. May I have him sworn?
Solemnly swear or affirm the testimony you're about to give be the truth, whole truth, and nothing but the truth. So help you God.
Yes.
Lower your hand, state your name.
Eric Buckner.
Sir, it is this court's understanding. Excuse me one moment. This is court's understanding that you're going to plead guilty to the charge of domestic violence second offense. That is a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
And understanding that you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5. It's on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on paper.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes.
of your own free will,
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes, sir.
On the date of May 2nd, 2025, at the location of 3000 Carpenter Road, Pittsfield Township, Washington County, State of Michigan, what did you do to Tamika King that makes you think that you're guilty?
We ended up getting into a physical altercation.
So, okay, so you were in an argument,
Yeah.
and what did you do with reference to that physical altercation?
It got physical.
Pardon?
Me and her, it got physical.
Okay. What did you do?
Oh, I put my hands on her. That's basically what you're saying, sir.
Okay. And you didn't have her permission to do that?
No, sir.
All right. And you weren't acting in self-defense at the time?
No.
All right. And you did that intentionally, is that correct?
Yes.
All right. And who is she to you?
My ex is my ex-wife.
At the time, was it your ex-wife?
No.
Okay, at the time it was your spouse.
Yes.
All right. Had you previously been convicted of the same type of an offense on or about, I don't have it here.
Your Honor, I have the date on the defense notice of 6/18/2013. The previous.
6/18/2013.
Correct.
All right. Had you previously been convicted of domestic violence on that date?
Yes.
All right. Sir, if I accept your plea, between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any sentence recommendation or evaluation. The court would not be bound by that. You understand that?
Yes, Your Honor.
And you understand that you could not withdraw your plea.
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
November 10th. Oh, no, November 17th, sorry.
November 17th, 2025, 1 p.m. I don't, what I was going to indicate, I don't know if on that other DV case, I think we got the wrong day.
We corrected it.
You corrected it.
Yes.
Okay, very good. All right. Bond will continue with its conditions. Thank you, sir.
Thank you, Your Honor.
Court calls case of the people versus the Darien, is it Stephanie Town
Ashley Feltus for the people.
or Stephanie Town?
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Staffney Towns. State your name for the record.
Adarian Townsend.
Townsend.
I really don't go by Staffney. Just I got two last names, but I really only go by Townsend.
But you got two names.
I know. I don't know why my mom did that.
You don't know what?
Why my mom did that.
But you don't like it, so you just keep one?
Yeah. I'm sorry. I just keep one. Yeah.
Is it the first one or the last one?
The last one, Townsend. Adarian Townsend is what I go by. But Staffney Townsend.
What's your mom say about that?
Like my mom last name is Townsend. My dad last name is Staffney. So she just gave me both.
Oh, what's your dad say, but you don't want to carry his name?
No.
Oh, well, never mind. My bad for asking. All right. Okay. I get it. All right. What are we doing on his case?
Unable to proceed, Your Honor.
All right.
Move to dismiss.
People being unable to proceed, this case is dismissed
All right, thank you.
Good to go.
that's without prejudice. You take care of whatever your name is. All right. Court does call the case, People versus Roman Hop.
Ashley Feltus for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Hop. State your name for the record, please.
Ramon Hop.
All right. I have before me a plea form that indicates defendant will be pleading guilty to the charge of malicious destruction of property. Sorry. 200 to 1,000, which is the 1-year offense, which I think is the stated count. Upon a successful plea to that charge at sentencing, the prosecutor will recommend a probationary sentence. And the victims are waiving any right to restitution in this matter.
That is correct, Your Honor.
All right.
That's our full understanding.
All right. Very good. May I have him sworn?
Raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so you got.
Yes,
Lower your hand, state your name.
Ramon Hop.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of malicious destruction of property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property destroyed or otherwise injured. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
All right. Still wish to plead guilty
Yes,
to that charge? How do you plead?
guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yes,
All right. You signed an advice of rights form. Is that correct?
yes,
Any questions regarding any of those rights?
no,
No? All right. On the podium, you'll see a copy of one. Please look at paragraph 5, highlighted one. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
no, sir,
Has anybody promised you anything other than what's been stated here today to get you to plea?
no,
Has anybody threatened you or coerced you in any way?
no, sir,
You're doing this voluntarily
correct.
and of your own free will,
Yes, sir,
and because you believe that you are indeed guilty of this offense?
yes, sir,
I'm sorry.
yes, sir,
Yeah, okay, thank you. On the date of December 26, 2024, the location of 2564 Deek Avenue in Pittsfield Township, Washtenaw County, State of Michigan. What'd you do that makes you think that you're guilty?
I destroyed a statue and a doorbell camera.
Okay. And so this was at a residence that you did?
Yes, I used to live there.
Pardon?
I used to live there, sir.
You used to live there? Okay, but you don't?
No.
You didn't at the time?
Not for years.
Okay. And so you destroyed those things. You didn't have any property interest or ownership in any of those properties.
I had some property at the house stored, but I was there also that day to get that property back.
Okay, I got you. But as to the statute and the Ring camera, those weren't.
No, correct.
You didn't
correct,
buy either
No.
one of those, correct?
Correct.
Okay. And you didn't have the owner's permission to destroy any of that property or do anything to it. All right. And you did that intentionally, sir?
Yes.
All right. Would you stipulate or agree that the value of those two items combined was in excess of $200?
Yes. Like
That's-
excess or it was,
Yeah, it was more than $200.
$200 or more.
yes. Yeah.
You would agree to that?
Yeah.
Okay. Sir, if I accept your plea in this case, I have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence agreement or evaluation in the case. You understand that?
Yes, sir.
And you would not be entitled to withdraw your plea. You understand
Yes,
that?
sir.
All right. Counsel, are you aware of any other promises, threats, or inducements that have led to this plea?
No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Before satisfied.
Satisfied, Judge.
All right. Court will accept the defendant's plea to this charge. We'll count one.
Let's take.
Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
November 12th at 9 a.m.
November 12th, 2025, 9 a.m.
Your Honor, I know your next sentencing date is the 22nd. I know that's a quick turnaround, but given Mr. Hop's time he's done, we are asking for the 22nd.
His time is done.
He's been in custody for quite some time. He's eager to get assessed, get seen by probation,
Warehouse.
get this case resolved. He is
Go
sorry.
ahead.
We were also going to renew our bond request that the motion was on Wednesday, and this court denied that motion. He did want to renew that request. That housing is still, present for him. We just don't know how long it's going to be available. So that's why we're requesting such an urgent date.
I do think he's still held on the felony, just so the court knows, Your Honor.
Yes, that bond's $100.
Yeah.
Is he gonna be able to post that? Or-
He thinks he may be able to. I mean, this is bond denied, so obviously this is driving the bond truck here.
Sentencing before the 27th.
The 27th, so the original.
Right, because he had violated the terms of his release, it's just why his bond was denied.
Right.
Um,
The date he's gonna, I asked for.
I just don't think, and I can't. You're basically asking 3 days from now for probation to be able to interview him and do everything, as well as talk to the victims of this, and I just don't know that that's gonna happen. I mean, if I set it for that day, I don't know that we're gonna have all of the information that we need. So I'm gonna set it for the 12th. That.
If also, so I'm sorry. I can talk to probation, maybe if things are done quickly, we'll contact the court if, depending on what Ms. Pilara can,
I just don't want to lose my housing.
yeah, we're just really concerned about the housing issue, Judge.
No, I understand that, but I
It's
also
6 years.
have to try to put things on a reasonable time frame and don't want to stress my probation department either, but.
I will add, if I may, regarding the bond argument. I know the court said you would consider any additional information that I was able to obtain. I did reach out to CMH to see what they recommended as for a mental health plan moving forward. The gentleman, Mr. Hop's caseworker, and just indicated that housing was their primary focus, that the CMH's mental health recommendation moving forward was to get him into housing. So they didn't have anything additional to add that he's already doing, which is he does report to CMH for medication. So I don't have anything else. I know the court requested that information. I don't have anything else to add, except for that was their, primary recommendation for his, mental health journey. So again, that's why we're just trying to make things happen,
Yeah.
Judge. Obviously, the county has to do what they have to do with the housing, but we want him to be able to take advantage of it if possible.
Anything else from the people?
No, Your Honor, I think I've made my position pretty clear to the court with our bond motion on Wednesday, and the court understands the struggles with secured housing,
Yes.
but also understands the struggles with bond violations that lead to new cases and all the things that are sort of going on in the periphery of that issue.
I don't see a basis on which I would change my decision. I think I would still keep his bond as denied. I'd like to see everything regarding his sentence and know as much as I possibly can about this. The events, as I understand them, are a bit concerning to me, and then the violation on top of that adds concern. While I'm certain he would be going into Avalon Housing, you talk to CMH. First thing is, I'm not going to do anything until I see an absolute plan as to what some structure around him that's going to prevent further activities by him. So that's going to be one thing. But I also want to see the full outlay of it. And particularly, I want to make sure that the victims of this offense, that their views and what they might say to probation are fully considered by the court before releasing it. So I'm going to deny again the request for a bond reduction. All right.
I'll see what I can do.
All right. Thank you.
Thank you.
Sir, good morning. You are Jamar Marquise Westwood, and your date of birth is June 28th, 1994. Is that correct?
Yes.
All right, Mr. Westwood, good morning to you. This is 25L000678. Mr. Westwood is before the court for a pretrial conference. It appears a third pretrial conference. Ms. Arnold, how would you like to proceed with the pretrial conference at this time?
Yes, Your Honor, Sophia Arnold for the record. First, I would like to readdress bail. We would like to argue for PR release today. We'd like to note that according to his history, he only has a couple of convictions and they're back from essentially 2013 and 2014. He has a few things pending, but is entitled to the presumption of innocence. And he's been going through kind of a lot lately. He had his phone stolen, so he didn't have a way to get a hold of anyone. And he's kind of been couch surfing, but now he is staying at his uncle's in Tacoma and he can catch the bus to come to court. So we believe that he will appear and that he's not a danger to society. And we ask that the court releases him. And given the pretrial, we are going to set that case for trial. So we would be asking for an out of custody pretrial court date.
Thank you, Ms. Arnold. Mr. Tuninga.
And Your Honor, I would note that, first of all, the city opposes the defense request for defendant's release on personal recognizance. I would note that the defendant initially failed to appear for arraignment back on April 22nd, 2024, and was arraigned on June 9th, 2025, when he was booked into Nisqually jail. Then later he failed to appear on August 28th, 2025, where he is now appearing in Pierce County Jail due to having been booked on subsequent charges out of Tacoma Municipal Court. So the city has both concerns regarding the defendant's ability to appear. I know defense did touch on that, but more concerning to the city is the protection order violation, domestic violence, and malicious mischief in the third degree domestic violence with an active protection order out of Tacoma Municipal Court, date of violation just 2 days ago. So the city would ask that the $10,000 bail, which I believe the defendant is still being held on, remain, Your Honor.
Your Honor, and if we could supplement the record just in response. So the first arraignment, the mail was sent to what seems to be the protected party's house, so he wasn't able to get that. And then in terms of missing pretrial, as I mentioned before, he's been trying to essentially figure out where to stay and how to have contact. Now he has a stable place to stay, and I have an updated phone number for him, so I'll be able to stay in contact with him. And then lastly, I'd like to mention that the no contact order allegation that just came out, they're different victims.
I'm sorry, say that last part again.
They're different victims it's a different victim than the one in our case.
Give me one moment, please. I'm just reviewing some docket orders. So, Ms. Arnold, just so I'm clear, your understanding is the charges that are currently pending in Tacoma Municipal Court, charges of malicious mischief in the third degree and domestic violence court order violation. Your understanding is that the alleged victim, and for those two counts, is a individual different than the alleged victim in this case. Is that accurate?
That is accurate. The alleged victim in our case is someone by the same last name. I believe it's Judith Westwood, whereas the new case in Tacoma Municipal is an individual by the name of Allison Bundy.
Thank you.
And Your Honor, I have checked the protection order issued out at Tacoma Municipal Court and is protecting one Allison Bundy.
Thank you very much. Okay. The court has some concerns here. I'm taking into consideration what Ms. Arnold has indicated about the failure to appear at arraignment. That makes sense to the court. It could have been that Mr. Westwood failed to appear for that arraignment, frankly, because he did not receive notice. He was subsequently arrested on a warrant At that point in time, counsel for Mr. Westwood argued for release on personal recognizance at that time from the Nisqually jail. And the court agreed, and Mr. Westwood was released on personal recognizance. He was given a date at that time for a pretrial conference. He appeared at that pretrial conference through counsel pursuant to CRLJ 3.4 on June 26, 2025, at which time counsel requested a continuance for further investigation. But that continuance was granted. The pretrial conference was scheduled. It was continued to July 15th, 2025. Appears that was another 3.4 appearance on July 15th. Continued again to, I believe it was, August 28th. And at that time, there was a failure to appear. Court issued the warrant that was served just a couple of days ago on October 15th. So I have at least one failure to appear where I know Mr. Westwood had notice of the hearing and he still did not appear. That is coupled with the concern that has been raised by the prosecutor, which is not only that he failed to appear for that pretrial conference, but there is now probable cause to believe that he also violated the court's order to have law-abiding behavior while out of custody on pretrial conditions of release. That's obviously concerning to the court, especially since the charges in this case are domestic violence related. And two of the new charges out of Tacoma Municipal Court are also domestic violence related. However, the court does have to balance that against the presumption of personal recognizance release. I am looking at Mr. Westwood's criminal history, and Ms. Arnold is correct that there is some prior criminal history, a reckless driving from 2013, an assault 4th degree from 2014, but it's pretty old. The court is going to go ahead and grant the defense's request for release on personal recognizance. Ms. Arnold, I'm doing so with some trepidation, and I hope Mr. Westwood understands that. I don't like the fact that he's been accused of new offenses while he is out of custody on pretrial conditions of release in this case. And I don't like the fact that I know for sure there's at least one hearing, the last hearing, that I'm confident he had notice of, that he failed to appear at. So I'm going to release him on his personal recognizance, but this will be his one and only opportunity to be out of custody in this case going forward. Any future failures to appear, any future new allegations of criminal behavior, the court will reimpose bail and take Mr. Westwood back into custody.
Understood, Your Honor.
Okay, and I do see the pretrial order form. You're asking to set the matter for readiness on November 13th. It appears that discovery is complete. Ms. Arnold, I do see the waiver has been filled out. Thank you. Mr. Tuanenga, have you had an opportunity to review this pretrial conference order, sir?
Yes, Your Honor.
Do you have any objection to the form of this order?
No, Your Honor.
Any substantive changes that the prosecution would like to make?
Let me just pull it up again.
Of course.
No, Your Honor.
Okay, Ms. Arnold, there's not really a good place for it on the pretrial order, but just so that you're aware, in the other box, I've indicated defendant is released on personal recognizance at this time.
Let's see. I'm sure it'll update any second, but sounds good to me.
Okay, let me save it. Yeah, because on the pretrial conference form, I don't see any other section that allows for comment on pretrial conditions of release other than abide by all previously imposed conditions, which obviously is the order of the court. So the court has signed that order. Mr. Westwood, I think there might be a couple other things holding you out of Tacoma Municipal Court. Obviously, I have no control over those orders, but you are going to be released in this case at this time. You need to be here at the Lakewood Municipal Court for your readiness hearing on November 13th at 1 p.m. Now, if you are still in custody on those Tacoma Municipal Court cases, you need to make sure that you're communicating with Ms. Arnold, because what I don't want to have happen is for you to have an out of custody hearing date, which you do. Is November 13th is an out of custody hearing date, only to find out that you can't come to court because you're still in custody on orders out of the Tacoma Municipal Court. So if that happens, as we start to get into November, you need to make sure you touch base with Ms. Arnold so that she can amend the hearing date to one where you can appear from the Pierce County Jail. Does that make sense?
Yes.
All right. Or to sign that order, we'll see Mr. Westwood back here on November 13th at 1 p.m. Ms. Grisco, I believe we have one last matter, and that is Mr. Satterwhite. Sir, good morning there in the Nisqually Jail. You are Glenn Satterwhite, and your date of birth is April 9th, 2001. Is that correct?
Yes, that's correct, Your Honor.
All right. Mr. Satterwhite, you are before the court in two different cases this morning. 25L004679 is a matter that is scheduled for a pretrial conference. There is also a new case, 25L004700, in which you are before the court for arraignment. You've been charged by the city of Lakewood in the new case with one count of domestic violence court order violation. Ms. Grisco, are you prepared to proceed with Mr. Satterwhite's arraignment at this time?
Yes, Your Honor, I am prepared. Mr. Satterwhite and I had discussed, and we do believe that he understands his rights. We would also like to waive a formal reading. I believe that probable cause was found for the case ending in 4700 already. And then we'd like to enter a plea of not guilty. We also did discuss finances. I believe that we're already appointed to the case ending in 4679, but would ask to be appointed to this one as well. And I do have a screening form that I can send to the court.
Thank you very much. And the court will review that screening form when it is filed with the court. Based upon that record, though, in the meantime, the court is going to appoint the Horwath Law Offices to represent Mr. Satterwhite in case number ending in 4700. Court will order the execution of a promissory note that is subject to waiver upon the court's review of that screening sheet. The court will waive formal reading of the criminal complaint in case number ending in 4700. The court has previously found probable cause. The court will enter a plea of not guilty as requested by Ms. Grisco. At this time, the court will next hear from the prosecutor regarding a recommendation on pretrial conditions of release. Mr. Tuaninga.
Your Honor, the city is requesting that $1,000 bail be imposed on each case. This is based not so much on the new charge, the arraignment, based on the fact that that's got a date of violation of 9/3/2025. The city is just choosing to bring this at a later date. The 4679 matter has a date of violation of 1 day afterwards of September 4th, 2025. But based on the fact that the defendant has failed to appear for the 4679 matter on September 23rd, and we are now seeing the defendant in custody as a result of that, and the fact that the defendant has a new criminal law violation in violation of his conditions of release on the 4679 matter with the new criminal charge, criminal trespass in the first degree out of SeaTac Municipal Court. So it is under that basis that the city is requesting the defendant to post $1,000 bail on both the arraignment and the pretrial case, have abide by the active protection order. The only protection order I see is out of Tacoma Municipal Court, and have no criminal law violations during the pendency of this case.
Ms. Garisco.
Your Honor, we would be asking for Mr. Satterwhite to be released on his personal recognizance. I do see, as Mr. Tuninga pointed out, that there is something in SeaTac Municipal Court. However, that is just an allegation, is not a conviction. I would also like to note for the FTAs, Mr. Satterwhite's address is at the residence that he is unable to go to. So any notification from the court, he's unable to get. It's not that he is attempting to miss court dates. He wants to appear, he wants to be in front of the court and get these matters resolved. But with the situation that he's in now, he has unstable housing. He can't get notice. He also had when he found out that the notices were, when he found out that he was failed to appear, he did schedule to get his warrants quashed that were set for October 30th at 8:30 a.m. And he attempted to get them. He scheduled those quash hearings October 2nd, 2025, when he learned of it. So we do ask for the court to release him on his personal recognizance.
So the court does see that in case number ending in 4679, Mr. Satterwhite was arraigned on September 5th, 2025. It does appear that he was released on personal recognizance at that time. Pretrial conference was scheduled for October 2nd, 2025. However, it does appear that a couple days later, on September 8th, Mr. Satterwhite called the court. The court clerk verified with him at that time his best mailing address. So that was the address that was provided by Mr. Satterwhite on September 8th. And it was advised of the hearing date and time. Now, it does look like that date got moved up, though, from October 2nd to September 23rd to coincide with the arraignment date that was scheduled on case number ending in 4700. It looks like notice was sent to Mr. Satterwhite on September 12th, presumably at the address that he provided when he called in on September 8th. And he failed to appear on September 23rd. I do see, as Mr. Garisco has noted, that on September 29th, we received another call from Mr. Satterwhite. He was advised that a warrant had been issued, and he set a quash date for October 30th, 2025 at 8:30 a.m. But then it appears that the warrant was served when he was arrested on the new Tacoma Municipal Court case. Looks like the warrant was served on October 16th. So there is a concern that I have here that Mr. Satterwhite, clearly he has the ability to communicate with the court. Clearly he has the ability to contact us, confirm his court hearing dates and times. It does appear Mr. Tuninga is correct that he has now amassed a new charge when the court previously ordered him to have law-abiding behavior. So that is of concern to the court. However, that is just an allegation at this point in time. I'm going to give Mr. Satterwhite one additional opportunity to remain out of custody in this matter. But if Mr. Satterwhite fails to appear at any subsequent hearings, or if he is charged with any new criminal offenses while this matter is pending, the court will impose bail and take him back into custody. but the court will give him one last opportunity to be out of custody in these cases. Court is going to release him on his personal recognizance at this time. Court is going to set a pretrial conference in this matter for December 4th, 2025 at 2 p.m. here at the Lakewood Municipal Court. Mr. Satterwhite must appear in person and on time for that hearing. I'm also going to remind Mr. Satterwhite that he must remain in contact with his attorneys from the Horwath law offices. If he gets arrested or charged with any new crimes, he needs to contact his attorney. If he's not sure of his court date, he needs to contact his attorney. If he has any questions at all about what he can and cannot do while these charges are pending, he needs to remain in contact with his attorneys. Court is going to order that he have no criminal law violations, that he update the court of any change in his mailing address, that he abide by all valid court orders, including no contact orders with the alleged victim in this matter, Corinne Shanice Davis. Court has signed that order. We will see Mr. Satterwhite back here in person and on time on December 4th, 2025 at 2 p.m. here at the Lakewood Municipal Court. Mr. Satterwhite, you should be released here later this afternoon, okay? All right. Thank you very much, sir. That will conclude your hearing. Ms. Garisco, Mr. Tuaninga, I believe that concludes the Nisqually calendar. Is there anything further from either attorney before the court is at recess?
No, Your Honor. Have a nice weekend.
Hope you both have a great weekend. Thank you very much. Court will be at recess.
The next case I have is State of Kansas on behalf of the Secretary for the Department for Children and Families et al. Versus Christopher McGee Sr. The case number is Butler County 25 DM 018. The DCF appears by and through Ms. Hawks. Are there other appearances on this case?
I didn't hear it right. For Christopher McGee? Yeah, you said that.
Yes.
Yeah, and I'm Ada.
You're Miss DeWitt?
Yes.
Okay. And is Mr. McGee appearing there with you as well?
Yeah, he's right here. Sorry.
Okay, that's all right. All right, Mr. McGee and Ms. DeWitt also appear in person and pro se. This matter was last before the court on September 19. It was continued to today's date. There are, I think, historically have been some questions that might be as yet unresolved concerning the nature of the rearing of the children at this point. Ms. Hawks, do you have any additional information, any questions for Mr. McGee or Ms. DeWitt, or any proposed way forward?
Your Honor, I guess I would have to see if the parties are still residing together. I think that's kind of been the issue, is that they may be living in different households, but are together and raising the children together. It sounds like there was maybe a plumbing issue and why they were living in different households. But it still remains that Mr. McGee is not listed on the services that they're receiving from the state. So we still need that application updated to include Mr. McGee as in the household. Otherwise, we need to establish child support.
All right. Mr. McGee, do you have any update for the court, sir?
No, we're still having, can't find the leak. It's actually underneath the house somewhere, but, you know, since I figure it's my fault on a lot of it, whatever you guys want to do. The only thing I got a question about is Emmy. Why is Emmy on here when she's 18 years old? He's been 18 for 2 months.
Well, it's probably by virtue of the fact that the matter was begun prior to her birthday is what I'm suspecting.
Okay, I
And
was wondering about that.
there
Like-
also, has she already graduated high school?
Yes.
Okay,
And Your Honor, this was filed in January.
right.
Okay.
So with all of that in mind, Ms. Hawks, it sounds like Mr. McGee is acknowledging that this has played out over a longer arc of time than he had anticipated, and he's willing to go forward in whatever direction I think makes sense to the court and frankly, what makes sense to DCF. I guess from my perspective, we're down to a couple of options, either establishing support today based on the acknowledgement of Mr. McGee or setting this over one more time. And I think we've said it over one more time, 3 times already. But
Well, I don't want to sorry, I didn't mean to interrupt you. I just don't want to cause any trouble. So whatever.
Well,
I mean, I would love to have a little more time, but I don't.
We can't find the leak underneath the house.
I'm gonna have to turn the wall and try to get under. They got whoever built the house, crazy.
But so I need to, what do I need to do? I need to include Chris on my stuff because I don't get food stamps or anything like that anymore.
Haven't got that for a long time.
Ms. Hawks, you might have a better, well, and I'd also like to hear your perspective on this, but I don't know if you want to speak to whether or not services are still being provided in any form or fashion, or whether or not you could easily adjust any worksheet to acknowledge the majority of one of the children.
So, it looks like at least the minor child is still on medical. And so some of our medical is mandatory, some of it is not. Ms. DeWitt can contact Child Support Services to determine if that is a mandatory program that she has to participate in Child Support Services with. If it's not, then she could request that she withdraw her assignment of rights through us, and we would close out the case, and it would no longer be a 4D case, and we could dismiss. If it is a mandatory program, then her options are to either add Mr. McGee to the application to include whatever income he has to be considered for her application for services. Even if they're not under the same household or same roof because of a plumbing issue, he could still be on the application, and then we would dismiss the case, or we proceed with child support. And then I can file an updated child support worksheet with only the youngest child on there, and then we would only establish child support for the oldest child between the first of the month after the petition was filed through the date of emancipation, and then it would be for the youngest child going forward after that. And assuming we continue today, which I think is probably the best option right now, it was my intention to ask one of our support workers to reach out to Ms. DeWitt after sometime, after this hearing in the next couple weeks to see if they could assist her with some of this.
Can I ask one more question, or if I can remember both the questions, huh?
Go ahead.
Okay. Last time she said something about, you did too, about going to DCF, and I got the number. I tried to call them, but I don't understand. They never did call me back or nothing. I don't know. I don't understand that part. And there was another question that may come to me. I've been having lots of issues lately.
I mean, Albert needs to be he's on United Health insurance right now. And
that was the other question.
Needs to stay on the insurance.
And I can tell in the system that Mr. McGee did call Child Support Services, but we're not the ones who add Mr. McGee to the service application. We're just child support services. He needs to
Okay.
call the division of DCF that actually provides the
When did-
services.
I got a hold of a
who
couple
you
and they
signed up
kept-
for. With.
So need to go ahead and go in and sign up for it anyway, or whatever you guys find that we need to do?
Well, I
Okay.
think that there are some options that you have, but these are options, frankly, that you'll have to decide what works best for yourselves and your family. And beyond that, I think that as you're discussing those options, you probably need to be doing that, as has been suggested by Ms. Hawks, with the appropriate people at DCF. And depending on your choices, updating documentation, or as has been suggested, if the medical program isn't mandatory, I suppose it's within your rights and you could consider the propriety of withdrawing and putting this case in a posture where this case at least could be dismissed. So you have some choices to make that nobody should be making for you. I'm willing to continue this one more time, as Ms. Hawks has suggested. And look, I feel like I am right there with you when it comes to kind of being overwhelmed with the number of issues that might be coming over the transom at a given moment in time. But this case has meandered for quite a while, and I appreciate your frankness in explaining that, there were things that, you might in hindsight have done better, and that you're willing just to accept whatever might be done. But I hope that you can dust yourself off and forgive yourself for whatever you think you might have been able to do better through to today's date. But I hope you would feel some new energy and some new urgency, both of you, to contact DCF, even if it means making a trip to an office. Ms. Hawks has indicated she'll ask that a DCF worker reach out to you. But I think you need to understand, in a somewhat complicated environment, but you need to understand your options and what's best for you. And you need to make decisions. And depending on what decisions you make, there are different directions that this case could potentially go. It could be the case that there is a winding down of this case entirely. It could be the case that there would be the need to do a new worksheet for at least any time post your daughter's turning 18. But again, nobody should be advocating for you more than you're advocating for yourselves on this. And I think you need to be very focused on trying to make use of whatever time is available to you between today and whenever we reconvene, to try to get those things sorted out in the way that's best for you. And that's my hope for you. Yes, sir. Ms. Hawks, do you have a date in mind as to when we might set this over to?
Your Honor, I'm thinking maybe that December 19th date. I'm pulling that up now to see what time would be the best time that day.
So you're saying I don't need to get a hold of you, want us to go through the SRS, or do you want me to somehow get some information to you if you need to?
Yeah, you have some choices to make. You can ascertain whether or not the medical is mandatory, and if it isn't, if you thought it was in the big picture the best thing for your family, you could withdraw your daughter from that program, and this case could be wound down. On the other hand, if you are going to continue to receive services either mandatorily or by choice, you're going to have to update the application to include, Mr. McGee, your income, your circumstances, and then from there, there could be presumably a new worksheet calculated when we could have that available, or at least maybe for a point of discussion when we reconvene on that December 19th day.
Okay.
And what time on the 19th was that, Ms. Hawks?
Your Honor, we could do a 9:30.
9:30?
Yes, sir.
That'd be
So
great,
what-
because we go through the Augusta Library, and they don't open until 9. But it works
Okay.
out great for us.
Yeah.
All right.
Quieter and everything else.
Well, we'll continue this then to December 19th at 9:30. We'll use the same Zoom meeting ID and passcode, and we'll look forward to seeing you both then. And I would exhort you, please, to take whatever proactive steps are available to you to get the information and the options that you have and make the choices that are best for your family.
So is the information going to be sent to us so we can kind of look at, my biggest problem is I'm hard of hearing, been that way most of my life. But it's easier for me to read it and stuff. Is there a way?
I think the best thing for you to do is to, and you mentioned this on an earlier occasion, but I think you need to go physically in person to a DCF office.
We did that.
Okay, and when did you do that?
I have been about 3 weeks ago, maybe at the most, when we went to
And-
DCF in El Dorado. You were there with me. You weren't? Oh, maybe I was by myself. Okay.
I wasn't with you.
All right. Got mixed up on that one.
Yeah, well, I think that it would just be important for you to drill down as much as you can by whatever means are available to you to
All right.
talk to DCF, and then y'all can make the choices you think are best, and we'll respond to those when we reconvene on the 19th.
Okay, thank you.
All right, thank you.
Thank you. Thank you both.
Well-
Have a good day.
Yep, you too.
This whole thing got started from a utility bill, and when I found that they kept saying at the city that I was losing water, but it didn't look like it was that much. It was a little over a month ago. We had 66,000 gallons of water being used. It's like, what?
Right.
Yeah,
Well, I'm
so-
sorry you're contending with that. I can't imagine.
Well,
I
no, that's
wish-
just my
Yeah.
fault. I should have dug into it a little quicker, I guess, is what I should have done.
All right, you have a good day.
You too. Thank you both.
Thank you.
And if you change your mind on anything, just let me know, please.
Changed my mind on what?
Well, what else you want me to maybe do or something? That'd be all I would ask.
Well, that'd be through her.
I don't know.
All right,
Thank you.
thank you.
Thank you. The next case I have is State of Kansas on behalf of the Secretary for the Department for Children and Families et al. Versus Aaron Russell. The case number is Butler County 25 DM 114. The DCF appears by and through Ms. Hawks. We're here on a motion for default judgment for paternity. Is Mr. Russell present on the call? Does not
Your Honor,
appear.
I'm here for the Jacqueline Miller case, just so you're aware. I didn't want
Okay.
you to think I was here for this particular case. And I believe
Okay.
we're 9:30 as well.
Oh, all right. Thank you so much.
Apologize. Thank you.
All right. And Ms. Hawks, in the circumstances, how are you wanting to go forward on the Russell case?
Your Honor, since neither party is here to make any statements regarding paternity, and we do not have any presumptions, I'm going to request the court order genetic testing.
Well, that will be the order of the court, and if you could prepare the appropriate documents, I would appreciate it.
Thank you, Your Honor.
Thank you. I'm going to go off camera and off mic just for a moment to make a note.
Thank you.
Good morning. We are on the record in the matter of the marriage of Jessica Rosine and Kyle Gibson. The case number is Butler County 14 DM 090. DCF appears by and through Ms. Hawks. Mr. Gibson appears in person and pro se. Ms. Rosine appears in person and pro se. Ms. Rosine, I think at one point along the way, you may have been represented by Mr. Swenson. Is he no longer representing you in this matter?
No, sir, he is not.
Okay. All right. We're here on a motion seeking modification of child support. Basically, amending or proposing to amend from the current order of $1,044 per month to $916 per month. Ms. Hawks, could you please describe the nature of your proposal and any changes to your prayer at this point?
Yes, Your Honor. So the state did file a motion to modify child support. This previously, at the beginning of the year, the child support obligation had been $232. And then a modification was sought early spring towards the summer. And that's when it was modified to, I believe, the 1,044. Another modification has been sought, and I prepared a child support worksheet that shows a guideline amount of $916. First, though, before we get too far into this, I would like to ask if father is receiving any VA disability or retirement benefits. I had spoke with mother and she had asked me that question. I looked at father's domestic relations affidavit. It did not have that listed on there. I just found out yesterday that we do have the ability to find out if an individual is receiving VA disability or retirement. We just don't have the ability to find out what that number is. So first I would ask father if he is receiving any benefits through the VA.
I think you might be muted, sir.
Okay, can everybody hear me now?
Yes, sir.
All right, this is all new to me, Your Honor. Before we get into the VA disability, I'd like to expand on what I believe Ms. Hawkins said. The case was originally closed for child support back in 2014, shortly after the divorce, and reopened in October with a $30,000 back pay and at $1,000 a month. So there was no, hey, this is going to be modified or nothing like that ever given to me while I was living in California. As far as the VA disability benefits, after serving 13 years in the Army, I'm rated at 30% and it's around $600 a month. Also on the child support worksheet Ms. Hawkins prepared, it doesn't list I have any other dependents, which I do. The pay amount that she has on here is $92,712. Is drastically wrong by at least $12,000.
Your Honor, if I may respond to that. So I did not include a multifamily adjustment because Miss Rosine had sought a modification back in May. Mr. Gibson chose not to participate in those proceedings. He did not respond to any of the correspondence from DCF to fill out any domestic relations affidavits or provide us with any information. So we went off an employer verification letter at that time. We did not know that there were any other younger children living in the home, so multifamily adjustment was not included. Now, Mr. Gibson is seeking a decrease in child support, and the guidelines allow for a multifamily adjustment at time of original order or when an increase is being sought. So Mr. Gibson's time to use that multifamily adjustment was in May, when an increase was being sought. Now he's asking to decrease his child support, and I don't believe the guidelines do allow for judicial discretion at all times, but I believe that the guidelines are specific that it's for the non-custodial parent when an increase is being sought, and he's seeking a decrease. And so that's why I did not include the multifamily adjustment. As for income, if you give me just a moment, I can speak to where I got that number.
And during this time in May, I was never received any paperwork, even speaking with DCF on the phone, never given any paperwork through the whole time. The only paperwork I ever received was in October, was when I got told, hey, you owe $1,000 a month plus $30,000 back pay, all the way dated back to the original divorce decree. I know it's hearsay, but speaking with DCSF on the phone, I was advised that the petitioner can open and close the child support case as many times as she would like. So there's never any paperwork received at my address that's been on file with DCSF since I moved to California, that was on file with her attorney at the time since I moved to California. No paperwork was ever received in the mail.
Okay.
Your Honor, Mr. Gibson provided a domestic relations affidavit with 3 pay stubs. I averaged the gross pay on those 3 pay stubs, which came out to an amount of $7,726 a month.
Mr. Gibson, are you suggesting that that number is incorrect?
Absolutely, sir. If I may, I'm not sure if I could show evidence on here. On the pay stubs provided, it has my pay plan grade step, which is a GL9 step 9. I'm a lieutenant for Federal Bureau of Prisons. As you sure know, is in a shutdown right now. I don't know if you could see this, but for my grade step, it says 86,365. Let me see, try to get this camera right. So if you see the highlighted section, right, 9, and then you follow all the way over. Oh, I hate these things. Can you get a clear view?
It's difficult for me to see. Maybe you could just read to me what you think is relevant there.
So it just shows my step and my pay grade, right? Which is GL9 step 9. The annual income is 86,365 for the Dallas-Fort Worth area. And that you can find that on the salary table 2025 for law enforcement officers for the Dallas-Fort Worth area. It's going to be different than regular street police or those, but that's what it has me making yearly. So there's 92,000. That was my income in California, supposedly at some point in time. But I took a $33,000 pay cut coming out here to Texas for a promotion. And Your Honor, if I may add, since October, I've sent DCSF 6 times modification paperwork. All 5 times they told me I never received anything and never received anything until this last time I was provided an email. So I emailed it to them and I also sent it in via paper. And now I have a court date.
As far as, and I'm not finished maybe hearing from any of the parties, but I do want to give Ms. Rosine an opportunity to weigh in. Based on what you're hearing to this point, ma'am, do you have anything that you'd like to add?
Your Honor, not particularly. That really pertains to the case and child support. In reference to him stating that the child support order previous was closed. I actually spoke with DCF on the matter. That was not anything that had to do with me. During the time that I joined the military and I went to basic training in AIT, and my mother was caring for the minor child. And since she was caring for the minor child, I was sending money home, and she also applied for assistance through the state. So when they closed the assistance through the state for my mother, that's when the case was closed, and that's what that reference is. But as anything else, I don't really have anything because this is about child support, you know.
All right, Ms. Hawks, having heard from both Ms. Rosine and Mr. Gibson, is there anything more that you wish to add at this time?
Well, Your Honor, it sounds like Mr. Gibson is receiving some VA benefits. I think I heard the number was 600. I believe our child support worksheet is 916. I suppose I would defer to Ms. Rosine. I think there's 2 ways we could do this. We could either continue this to give Mr. Gibson an opportunity to provide DCF with statements of his VA disability or retirement monthly statement, so we can include that income in the child support worksheet. If it is $600, it would probably increase that 916 slightly, but I don't know by how much. If Ms. Rosine's fine going forward with the 916, I would be okay with that as well today.
Ms. Rosine?
I would like it to be factored in, please, so we can extend it if we need to.
And with the extension, it, I think, would only be fair that Mr. Gibson be given an opportunity to present current income data as well. I mean, he's explaining that from his perspective, at least, the income that has been ascribed to him might be higher than his actual earnings. And I just want everybody to know that I'm very happy to extend this to try to get more data points and try to have as much precision as is possible in the calculation. But I just don't know where that will end up. I don't know if it would push numbers up or down. And of course, Mr. Gibson's also asking the court to consider whether or not there should be any adjustment for a multifamily discount. And I haven't ruled on that question either. But I think that given that there are so many moving parts, I think it's important that we try to get this right. And I think that I would like to set this over to give Mr. Gibson an opportunity to augment the income information that DCF has with any additional information that he has, so that a new worksheet could be computed. Certainly, Ms. Rosine, if there's any changes or additional information concerning your income, that would be important to also forward on to DCF. And then in the meantime, I'll consider the question, and I understand where the bias would kind of naturally flow, but I do understand the court has some discretionary powers as well. But I'll consider whether or not I think there should be any multifamily discount and or factored in. And then from there, what I would like to be the case when we reconvene, Ms. Hawks, if you can have your best worksheet available, but also open in case the court should decide to factor in the multifamily. We could do that hopefully in real time on the record. What kind of time frame do you think you would reasonably need, Ms. Hawks, to get information and factor those things into your new calculation?
Well, Your Honor, I always like to have at least 2 weeks before the hearing to be able to mail that out to the parties, and so at least a week before that to review that and give me time to prepare. I will say, and I'll go ahead and get these prepared for filing, the pay stubs that Mr. Gibson provided me that are from June and July, and they do have his base salary, so I am aware of that, but he does have some overtime so I factored in the gross. So if he's only going to provide me that pay scale, I don't foresee myself changing the income on the child support worksheet. I'm going to base it off of the gross income he's actually making. So if he can provide me pay stubs that are more recent than July 26th, that would show a decrease in income, I'll definitely consider that. But right now, what I have, I believe, is very accurate. So I guess depending on when the court wants to set this for hearing, I would say Mr. Gibson needs to provide the VA benefits and any income information to me at least 3 weeks in advance so that I have time to get that information out to the parties.
Can I ask a couple questions by any chance, Your Honor?
Yes, sir. Yes, sir.
So in factoring in the income withholding worksheet, the overtime on the pay stubs is not guaranteed. I'm a lieutenant at a federal prison with 1,400 plus inmates. The overtime is not guaranteed. Lieutenants are going to get stuck after their 8-hour shift. So same with the captain, the AW, and the wardens. Ms. Rosine knows she was employed by the State Department of Corrections in Kansas. As to her timeline she's speaking about, basic and AIT. So that was well before we were ever married. The case was closed after 2014, after the divorce was finalized. I have children on this worksheet that follow in each bracket. If you have any questions, please ask, Your Honor. I'm an open book, ma'am, Ms. Hawkins, you too. But the overtime is not a guaranteed thing. It's not every day. It's not something I want to do. As far as the insurance, the health insurance, I could provide health insurance coverage, dental, vision. I've never ran from anything, Your Honor.
Well, and nobody's implying that you had run from anything, and certainly I think everyone appreciates both of your efforts to serve our country and continuing to serve the communities you're in by the work you're doing now. So I don't want you to in any way feel demeaned, because that's not the purpose here.
I just feel like I'm getting railroaded, sir, to be honest with you. As of right now, I can't provide any pay stubs. The federal government's in a shutdown. I'm personally not getting paid. So there's nothing I can provide you more than what I already have. You take out the overtime, you include the VA benefits, something that I've earned that shouldn't even be included in this. But health insurance, dental, vision, I can provide all of that. I required a copy of the birth certificate and social security number. And this is just an unfortunate situation that should never happen, but that's another court hearing for a different time.
Well, I think that there are a lot of moving parts, and in all candor, I didn't read the file back to inception. So you're speaking about some historical data points that I'm not immediately familiar with. By the time we reconvene, I will have reviewed the file in its entirety. And I think that it might make sense for us to go ahead and set this over into early January. I mean, I know that none of us could speculate with any kind of certainty about when the government shutdown will come to an end. I believe there's some optimism that that might be sooner than later, but again, no way of knowing for sure. But I'd like to, if there is a time frame that kind of makes sense from everybody else's perspective, that would potentially allow for newer pay stubs to be submitted, if that's what you want to do, Mr. Gibson, that you'd have a chance to do that. I had, but I do not have in front of me January calendar. I apologize. Miss Jackie, what January dates do we have at this point?
We have January 16th, Your Honor.
Okay. Ms. Hawks, do you think, just given the nature of number of moving parts at this point, that might be a good date to set this to make certain that everybody has a chance to be heard in terms of documents that they submit to you, and also giving you some time to consider the data and perhaps run a new worksheet?
Yes, Your Honor.
Okay. Go ahead.
Oh,
Mr. Gibson and
Yes.
Miss Rosine, does that January 16th date at 10 o'clock in the morning work on your calendars?
Yeah, would that be better for in person out there in Kansas, or another Zoom meeting?
Well, it will be by Zoom again. I'll
By
be
Zoom.
using the same meeting ID and passcode that you're using today. Yes, sir.
Yes, Your Honor,
And
that's fine with me. I just need a date.
Okay.
And then
Yeah,
also,
go ahead, sir.
also, if I may, at the meantime, I assume it's going to be stuck at 916 or 1044.
It's at 1044 right now, pending any change.
How am I supposed to pay my rent? I've been lucky enough. I have a landlord that understands the court proceeding and understands what I'm trying to do, but I haven't been able to pay rent. My rent's at $1,000 a month. I'm not getting paid, so I'm kind of running out of gas money to afford to work. There's just some circumstances piling up on my end, and it's just unfortunate, Your Honor. I don't.
Well, it is indeed unfortunate, and I know that it sounds like your circumstances are much like those that many of us contend with, where even a brief interruption in the pay that we're earning from our work can have some pretty profound impacts through our household and with our families. But at this point, I think my zeal is to try to hear everything that you're saying, everything that Ms. Rosine is saying. And as far as a mechanism for any kind of modification, the proposed modification that I'm seeing at this point is, and I know when you're not getting any money, a dollar might as well be the moon, but it's a relatively small, what is it, $128 or something like that, proposed modification. I know Ms. Rosine is, from her perspective, reasonably moving the court to consider a potentially higher number if that's what the worksheet should yield. I know from your perspective, Mr. Gibson, you're wanting the court to consider a potentially, and from your point, reasonably meaningfully lower number. If the court were to consider multifamily adjustment, if the court were to be privy to some new numbers that might show, I think you said maybe an income of something like 12,000 less than was used on the original worksheet. Those are all considerations the court will have to keep in mind. But I think that at this snapshot in time, I would be in a position to think that the best way to go forward is to leave these other decisions until we have the data points and try to make a good decision once for all, rather than trying to meander around the milieu of different numbers in the meantime. And I do concede and I do understand, and I am very sorry that that works a hardship on you, but I think it's the most reasonable way forward from the court's perspective.
So then just to be clear, so it's on the record, when I send in another worksheet for the 7th time to include the birth certificates of the children living in the house and all that relevant information, again, that's what I need to do, correct? Is that what Ms. Hawkins is asking for?
Basically, I'm wanting you to feel latitude to advise the court in whatever you think are important considerations in this. So yeah, if you want to update the income numbers such as those pay stubs are available to you, and I realize the government's shut down, but I don't understand how that would necessarily make you in a position where you wouldn't be privy to your own prior pay amounts. I mean, it seems like those would be available for you.
The prior ones I can get, Your Honor. I'm just saying any new ones like from last weekend when
right.
I won't have any updated stuff. And unfortunately, sir, as a lieutenant, right, the overtime is gonna happen. If there's an incident in the institution, I'm stuck after my shift completing paperwork, medical assessments, getting inmates to and from the hospital. There's ins and outs that overtime sometimes is unavoidable. And it's not
and like you said, and like you explained, it's also unpredictable. So I understand where you're coming from there. But my prayer for you, Mr. Gibson, is that the shutdown ends quickly. I think there's, from what I'm understanding, just reading the news, having no expertise in the matter, there might be back pay provided at that point. And I know that would be a blessing for you. I hope that proves to be the case. But I want to, as much as is possible, make a good decision when we reconvene. I am going to set this over to January 16, 2026 at 10 a.m. And I didn't confirm, Ms. Rosine, does that date and time work for you, ma'am?
Yes, sir. It does work for me.
Okay. And I'll give each of you an opportunity to update Ms. Hawks to the extent you would wish to. And I will be, in the meantime, reviewing the file, and I will be considering the question of application of a multifamily adjustment. And if Ms. Hawks thinks it's appropriate based on the information she receives, she could run a new worksheet if she thinks the one she has accurately reflects the circumstances. We might have only that same worksheet available when we reconvene, but in either case, I'll ask Ms. Hawks that you have it up to the extent the court may wish to consider the multifamily adjustment.
Your Honor,
Yes,
before
ma'am.
we go, I would ask that Mr. Gibson be ordered to provide his VA benefits monthly statements to DCF by December 15th. And then if he wants DCF to consider any other income information, that also be provided by December 15th.
I think,
Oh, I
go ahead,
apologize.
sorry.
Additionally, I don't need birth certificates for his other children. I don't question that those are his biological children living in his home. I just don't know that I agree that he should receive credit for them on the multifamily adjustment based on the Kansas Child Support guidelines. But I'm not questioning the validity of whether or not they are his biological children in his home. I think it's just going to be whether he deserves credit for them on the worksheet or not, but I don't need their birth certificates.
Okay. Well, and I do think that December 15th deadline for either Ms. Rosine or Mr. Gibson to submit the data they would like to have considered and including the VA benefits makes sense, and that gives you a chance to work on that worksheet such as you deem it appropriate. And if a new worksheet is indeed submitted in the case, that could be mailed to the parties ahead of time so that hopefully we could move through to a conclusion on January 16th. All right. Well, look forward to seeing each and all January 16 at 10. And thank you, Ms. Rosine. Thank you, Mr. Gibson, for coming in.
Thank you, Your Honor. Appreciate it.
Thank you.